And welcome. This is Neil Daly with McGraw Commercial Properties doing another interview, and this time with Rich Marshall of Connor and Winters, an attorney here in town. The topic today is going to be force majeure. Now, Rich is a excellent, outstanding attorney with a lot of commercial real estate background. We've chatted a couple times, and we thought this topic would be very timely considering the air right now, just where we are in the middle of a pandemic, and why is this important? And so why is force majeure one of the most talked about legal clauses out there right now?
Well, first of all, Neil, thanks for allowing me to chat today. What's interesting is I've been doing this for 25 years, and I'm as guilty as anybody else that's been in the profession. A lot of times the force majeure clause is kind of at the end of the document, and it's kind of one of those boilerplate provisions that we all just kind of glance through very, very quickly, if at all.
Right.
And we just kind of move forward. But what's happened, obviously, since the pandemic is there have been a lot of disputes and actually some cases that have come out of the pandemic as to arguments as to whether or not the pandemic in and of itself constitutes a force majeure event. And,
Right.
and that in turn has required a lot of people to kind of revisit their clauses and determine what they have currently. Is it sufficient, or is it something that needs to be beefed up?
So force majeure, to quickly recap, is by definition, it's a French term that means, irresistible or superior force. And so that you mentioned that's the boilerplate language that often covers things like natural disasters, or commonly kind of vaguely referred to as acts of God, right? So that covers that. So now we get into pandemic, which is not specifically spelled out in most cases of force majeure language. And as you get into this, there's a lot of debate. There's a lot of people that have now come to a point where their business has stopped. They're either bankrupt, they're going out of business, they have too much space, and their lease costs are now a huge burden on the company. And so they go to the landlord. How do we get out of this thing? We'd like to terminate our lease. Hey, there's a pandemic going on. It's like, sorry, I'm the landlord. I got bills to pay. I got to pay for the building. And here's a bunch of things that come up. So in that force majeure, someone might say, well, I have a force majeure clause. Well, the landlord's like, well, it's not covered. Yeah, we would put it under acts of God, right? So there ensues the debate of some vague language. So as we move forward in negotiating these force majeure languages for new leases, or even if we open up during a renewal, possibly midterm, we've done it in mid-contract already this year, would you spell out specifically pandemic or epidemic? There's no more room for vague interpretations anymore, is there?
No, there's really not, and I agree with you. I think a lot of people are grasping onto anything right now to avoid payment of performance obligations, and there have been I've even had it in lending contacts where borrowers have said, well, we can no longer pay on the note because of the pandemic. And
right.
So as a result of that, I think we all have to look back at our clauses. And the first thing and the most important thing would be to try to be as specific as you can as to what constitutes force majeure events. What we often see, as you mentioned in the provisions, is it may just say force majeure is defined as an act of God. Well, that's great, but okay, where do we draw the line as to what an act of God is? I mean, obviously, we could point to a hurricane or tornado as an act of God, but is a pandemic really an act of God? And that's kind of a questionable thing that, again, is being litigated right now in the court. So I do think it would be very beneficial for people to list pandemic specifically as potential force majeure events. Other things that you can consider, depending on your transaction, is cyber attacks. So it can sometimes be a force majeure event. That's popular in software and technology contracts, but it could also apply in some real estate deals.
I think that's incredible. The cyber attack thing is brilliant, because now you're starting to think ahead, and now you start the wheels turning. All right, well, what else could come about? I mean, these force majeure clauses are going to get pretty extensive as you list every potential item that comes about. So cyber attacks, then you have to argue like, well, all right, so it's not really necessary an act of God. I'm sorry that it happened to you. The landlord would then say, I might be amenable to it as long as you took protective measures, right? So that's kind of the next point in the argument.
Yeah, so I think what we want to do is we want to try to be detailed with our list of what constitutes force majeure events, but I would encourage the drafter to tailor the list of events to the particular documented issue. For example, there may be different types of force majeure events in a construction loan agreement as compared to a lease or as compared to a software license agreement.
Right.
The other thing that's important is separate apart from listing out the events is to list out what items will not be excused by force majeure.
Right.
One of the key things there, which people always point to, is payment obligations.
The number one. That's got
Yeah,
to
the
be the big
argument,
one.
and I think you need to specify it because the role of brokers and transactional attorneys, I believe, is to make documents as detailed and specific as they can be, so that way a litigator can't get a hold of them, punch holes in them, and cause a fight.
Right.
So separate apart from listing out what constitutes force majeure, we need to list out items that are not excused by force majeure, and payment obligations are a key element of items that are typically not excused by force majeure. The other thing that I would always recommend on the force majeure clause is you got to, when you list out these events, you got to specify that the trigger makes it physically or legally impossible to perform the task at issue. Just because, for example, there's a pandemic, that may not in and of itself eliminate your ability to go and repair the roof. So,
Right.
so the force majeure event has to be something that results in you just not being able to physically or legally perform the obligation that's at issue or in question.
A government lockdown.
Exactly. That would
Right.
be a legal impossibility. There's a shutdown again, but you need the roof repaired. There may be a situation where you can't do it because of the governmental lockdown. But and the other thing to always, I think, recommend to people in the force majeure clause is to have a provision that says if you think a force majeure event has occurred, you've got a certain period of time within which to notify the other party to make that claim.
Right.
Because what invariably happens is, let's say the pandemic. Let's pick on the pandemic. And things rock along for 3 or 4 months. All of a sudden, the payments stop or the performance stops. What's happening sometimes is the party's going, oh, well, I can't do it now because of the pandemic.
Right.
Well, if that was really the trigger and the cause for your issue, you really need to be able to make that claim within a certain period of time. If you don't make that claim within a certain period of time, it's barred. That would be the recommendation on the drafting component.
And that's really hard to know because I think at heart, most people are going to be going, all right, well, if this is only a month or two, I can gut it out, right? I've got enough in reserves and I don't need to go borrow money. So people would be trying to do the right thing, drawing on their reserves in order to try to stay open. But now it goes 6, 8 months, a year and a half, then the people just run out of cash. And you can't retroactively go back and claim that, correct?
Yeah. That's and then pandemic's a little different than, let's say, another easier example would be if there's a tornado that hits your property.
Right. There's a
And
specific
that's a
time.
situation you got a hard one-time event, and what you could put in your clauses is that if there's an event like that, you've got blank amount of days, 10 days, 15 days, whatever it may
Make the
be,
assessment.
within which to make a claim that says, hey, I can't perform.
Right.
I can't engage in the continuous operations clause right now because a tornado hit my property, and give the other side notice of that.
One thing we talked about a second ago was the cyber attack. And so being able to claim a force majeure clause in that, you allude to it in some of the notes and we discussed it here. Preventable measures would be doing a lot of things like malware protection and phishing protection, putting in all those antivirus software components to make sure you're not susceptible to data being stolen or manipulated. What would you do for a pandemic? How would you make that preventable? So one of the questions that was asked in our group was, do you inoculate or vaccinate everybody as a preventable measure?
Yeah, that one's kind of tricky. I mean, I think you could let's say we're in the current market right now.
Right.
Is you could indicate that you are requiring people within your offices or within your building to comply with masking orders, to comply with spacing, If you're in a restaurant, it's obviously separating the tables and potentially putting the plexiglass up. But that one's a difficult one to try to tackle on how to best mitigate, especially in the current market. In the post-vaccine market, I mean, it could be that you've requested. I don't know if you can actually require your employees to have vaccinations, but you can make it as an encouragement policy that says, hey, we strongly encourage you to obtain the vaccination.
So the evolution of that is, I think, what we could see it play out in this example would be similar to a driver's license, where you don't have to go get a driver's license. However, you're not allowed to drive on the roads.
Right.
You're not required to go get a vaccine. However, you may not be allowed to come in the building or work at this company without it.
And that's going to be interesting to see how that plays out as far as employment laws. If there's going to be the opportunity for an employer to basically indicate and mandate that all employees have to be vaccinated. I don't know if that'll be something that may shake out here soon with respect to any types of infringement on civil liberties. And that I could see that definitely coming into a lawsuit situation if a employer is mandating that people have a vaccination before they work there. That'll be an interesting topic that is, I'm sure, likely to pop up here soon. But I would just on general, just non-pandemic items, I would, within the clause, the force majeure clause itself in the document require the party making the claim of a force majeure event to engage in efforts to mitigate the damages resulting therefrom.
Right.
I think that's an important component to consider putting in the force majeure.
Are there any current examples that you're working on where any creative language is coming up, or are these things playing out in front of you right now on lease negotiations?
They're coming up organically. What I have seen in a few documents, some recent documents that aren't what I would consider boilerplate real estate forms, either purchase or leases, you are seeing more expansive force majeure provisions that are now definitely including pandemics, epidemics. You're not really seeing cyber attacks in real estate transactions. That's not as important, but obviously the cyber attacks would be more important for other industries. But it's starting to get everybody's attention, and I think we all on the broker and transactional attorney side need to be cognizant of that and always kind of keep our antennas up when we're looking at force majeure clauses to make sure that they really fit our transaction and that they are comprehensive and have kind of some terms and conditions, if you will, before someone can actually exercise a right underneath them.
And that's where someone would benefit by talking to a guy like you who has seen all of these different types of contracts, seen all the different types of leases, knowing what you alluded to in the beginning is that this would be specific for this type of contract, either real estate or work contract or software licensing. And then you would involve the new and updated, most current language being used in the industry, defining those triggers and also spelling out the result in the event that the force could not be cured. Is there a backdoor to a termination option in that regard?
Yeah, in some transactions, and some people are recommending that you do have kind of an outside date. So let's say someone does rightfully exercise a force majeure clause. The drafters of the document need to consider, okay, if that force majeure clause is properly exercised, are we going to let this force majeure excuse performance forever? Or is there a certain time where we've got to look at each other and say, okay, it's just not going to work for us. We need to look to have an outside date within which either party could terminate the contract as a result of the force majeure event. And that's dicey. Obviously, if you're a landlord, you're fighting not to have that. But if it's a construction transaction, it may be a little different.
Yeah, it's similar to a condemnation language where X percent of the building is taken. Now, percentage-wise, odds are that very rarely happens. It does happen, that's why it's in there, but this is now much more close to home where if you can't solve this thing within a certain period of time, landlords are going to really push back on that.
Absolutely, say, yeah.
There's no way I'm letting you out of this lease if this government issue happens and it takes longer than 180 days to cure.
Right. Right, and obviously for landlords, especially in their structure. The money at issue is important, obviously. So that's why, again, that's that at the beginning of your force majeure provision, you kind of indicate, okay, these are things that are absolutely not excused for a force majeure event. So payment of rent, payment of CAM charges, and pro rata share of operating expenses. Those are
Right.
things that have to continue to be made, regardless if it's a tornado, hurricane, pandemic, cyber attack, or whatever else is at issue.
Right.
So, and I haven't seen, honestly, I haven't seen a lot yet of provisions that have an outside termination date in the event that force majeure goes on for an extensive period of time. But
Right.
I think we're going to see those come through. I think that's going to be kind of an organic process, especially in light of this pandemic issue. I think you may start to see termination provisions within the force
And a lot
majeure.
of things that would come into that, I think, would be, for example, what happened early on in this. If it wasn't included, people are saying, man, I can't go to work, I can't survive, I need a break. The landlord's response is, well, I'll give you a break as long as you have done the following and you have applied for the payroll protection
Hmm.
funds. You've applied for money under the CARES Act. You've applied for this and this and this. And once you receive those things, I expect to be compensated at that time. So there's a prescription of, I will be flexible as long as you've done X, Y, and Z. You've tried to get this stuff fixed. And so that's sort of the remedy solution era of those force majeure languages, where that language is going to have to be balanced going forward.
Yeah, and one other thing I would bring up, separate and apart from force majeure, is I would encourage, especially people that are in leasing, to consider what their business interruption insurance will cover. So you may want to revisit with your insurance carrier as to what items your business interruption insurance will kick in for.
Great point.
I don't think pandemic is one of those triggers yet for business interruption insurance, but I'm sure insurance companies are getting some kind of push, if you will, to consider expanding the list of items that business interruption insurance would cover.
Actuaries have been busy all year,
Yeah, yeah, absolutely.
penciling in some odds. Well, good. Again, Rich Marshall, Connor and Winters, I really appreciate your time today. As a bonus for anybody watching the video and listening to our recording today, Rich has put together a sample force majeure clause that does include a lot of the things that we have talked about today. It is something that you would absolutely want to have in your document library and your file folder to be able to cut and snip. I want to give you Rich's contact information. So Rich Marshall, partner with Connor and Winters, 4001 Williams Center, Tulsa, Oklahoma, 74172. Phone number 918-586-8526. Mobile number 580-220-8995. And email rmarshall@cwlaw.com. Well, Rich, I appreciate everything that you have talked about today.
My
All right.
pleasure. Yeah, I'm happy to share that sample form, and obviously, there's it's just a sample. There are tons of other things that we can add in and roll in as various concepts and terms, but it kind of provides a decent roadmap of maybe some bells and whistles to look to include within each force majeure clause.
So again, contact Rich. You can email him again at rmarshall@cwlaw.com and communicate with him in regards to that force majeure provision for you to have in your next lease or contract. So Rich, thank you very much. I appreciate you being here today. And thank you for everybody watching there on our monthly broadcast, I should say. Again, I'm Neil Daly with McGraw Commercial Properties, and we'll talk to you soon. Thanks.
Thanks, Neil.